This is Right to Life Radio with John Girardi on Power Talk 96.7 and AM 1400, a production of the Right to Life of Central California. And now, here's your host, John Girardi.
The California legislature is trying to legalize abandoning newborn children to death. What an open for a show. This is Right to Life Radio.
Happy Saturday,
Yeah,
folks.
happy Saturday. I wish I was exaggerating about that, but I don't know that I really am. So what are we talking about here? The California legislature is introducing legislation, or well, obviously the California legislature is doing it in the legislature in California. Anyway, a member of the California legislature has introduced a bill. And Jonathan, why don't you look up the bill number?
AB 2223.
AB 2223.
Yes.
And
you can find out more, just a John, shameless plug.
Yeah, sure.
If you
go to CaliforniaFamily.org.
CaliforniaFamily.org. It's one of the top blog posts. It's also on our Facebook page. We published it back on March 21st. And the title is Newsom's Abortion Council Opens the Door to Infanticide.
Newsom's Abortion Council Opens the Door to Infanticide, written by Greg Burt. All right. So AB 2223 is basically designed to eliminate all civil liability, meaning risk that the doctor or whatever healthcare provider could get sued, as well as all potential criminal liability, risk that someone will get prosecuted, for perinatal death, okay, for almost any kind of perinatal death due to actions or omissions related to the pregnancy, including, according to the language of the bill, including for any kind of perinatal death, including miscarriage, stillbirth, or abortion, or perinatal death. So we're eliminating criminal and civil liability for any kind of miscarriage, stillbirth, abortion, or perinatal death. All right? Now, you may be wondering what does perinatal mean? Okay, so perinatal, obviously the word natal has to do with being born, and the word peri is the Greek prefix that means around. Okay, so around birth, death. And perinatal death can refer to any death, according to some states, how they have defined similar kinds of legislation. Perinatal death can refer to death for any kid within his or her first 28 days of life. Now, why are they doing this? Okay. The reason why, Jonathan, I think they're doing this is because of this case. We talked about it once on this show, I think briefly. This case out of Kings County, where a woman who was a drug addict, I believe she was abusing heroin,
Yes.
was being prosecuted. She was being prosecuted by the local DA for the demise of her child. So she was using heroin. The child in her womb died. And Rob Bonta, the attorney general, sort of intervened, and basically a lot of people in the pro-choice universe were really upset about this individual prosecution. Jonathan and I, on reading this story, we weren't like 100% gung-ho. I think it's kind of a very difficult question about what the appropriate approach is to take for someone has a miscarriage because she is doing something within the course of her pregnancy that's not healthy.
Yeah.
And where do you draw the line between, like, what kind of thing has to happen? But what's the line between deliberately inflicting harm on yourself to, smacking hitting yourself or having someone else hit you to induce
Falling
a miscarriage
down the stairs on purpose,
or which, I mean, it sounds more like something an abusive husband would do, frankly.
Yeah.
But anyway, deliberately doing something to deliberately purely just induce an abortion versus maybe you have an addiction to some substance, you use it and something bad happens as a result that maybe you intended, but maybe you did not intend. Those kinds of cases, I think, are legitimately very difficult to suss out when criminal liability should be imposed, when some kind of parental like state intervention to help this person needs to be imposed. Like, it's a difficult question. It's not like a slam dunk, like all the pro-lifers are on one side of this and all the pro-choicers are on the other.
No. And John, I think I want to point out here, when we're looking at some of these situations, and particularly like, I don't know if you were designing a hard case. They talk all the time about, hard cases make bad law.
Yeah, this is a hard case.
If you were designing a law school hypothetical,
Yeah.
I don't know that you could do more than this. I mean, in this particular woman's case, this was not like, she took drugs once and this was her first pregnancy and oops, it was this horrible, tragic story. This was, I believe, either her 8th or 9th pregnancy.
Yeah.
Multiple fathers for multiple of the children. She also isn't a first-generation drug addict. If you read the story, she's not a second-generation drug addict.
A third-generation drug addict.
She's literally, her mom and her grandma were all addicted to drugs.
Right.
So I mean, it's like.
And whether is criminal prosecution in this case, like, is that really what this situation needs? Like, yeah. So anyway,
you could have,
it's a very complex case.
You could have, John, I think, a good faith discussion and say, okay, are there other sorts of intervention? Maybe not, a 40-year or 10-year sentence, which is, I think, what this gal had received in this case. It was a fairly strict sentence.
Well, and even Jonathan, like, if we were to construct our ideal, pro-life legal regime within the state of California, is this something that we would meet with criminal prosecution or with, civil fine or whatever? I'm not sure. I'm not sure exactly how we would structure it. We've thought about this more than most people.
If I could give a galaxy brain take on this,
sure.
Maybe if you are addicted to drugs and you are continually addicted to drugs, so much so to the point that your 8 previous children have been taken away from you.
Yeah.
Maybe incarceration or diversion to a treatment program
or something. Yeah.
Maybe that should begin before the 9th pregnancy.
Right. Or and there are also like different states have different programs of like civil confinement where someone's a threat to society, so that it's not a criminal penalty imposed on them, it's a civil confinement. But then that raises lots of due process concerns, like, you're just holding someone, against their will for, what's the charge? Yeah. So there's anyway. So it's a really difficult case. Everyone on the pro-choice side of the universe has 100% taken the position that this prosecution's completely bad. And so they wanted to introduce some kind of legislation to 100% prevent something like this happening again, a prosecutor prosecuting someone because of a miscarriage in this situation. From the perspective of pro-choicers, they 100% do not care that this unborn child died, which is the failure in how they address this. Because, John, I think actually the child is a valuable member of the human family here whose rights should be subject to our concern in all of this. It's not just a nothing burger that we shrug our shoulders at that this miscarriage happened because this woman was abusing drugs. Like, it is a preventable thing that now someone is dead as a result of. So at any rate.
And I think the incredible tragedy is that nobody denies, again, trying to find the common ground here with our friends. Nobody denies that it is a tragedy that this child died. And
maybe some people do. Well, that's what I'm saying is I don't know that people on the left do. I think people on the left sort of have taken this posture that we would have been totally okay with this child being aborted. We don't really recognize the same kind of human dignity that this child has.
That's the real hard part.
At any rate, this legislation has been introduced as a means of combating the idea of a prosecutor prosecuting a woman for the wrongful death of her fetus as a result of, in this case, drug abuse. This is kind of like using a sledgehammer to swat a fly. Because what this bill does, it goes way beyond an instance of a woman has a miscarriage. A woman has a miscarriage because of drug use or something she did, and she's immune from criminal prosecution as a result of it. This extends immunity from civil liability and criminal prosecution all the way out to any form of perinatal death.
Right.
Which I find to be just astonishing, because more or less what it has legalized is infanticide. I mean, a certain kind of infanticide. It's the precise thing that Ralph Northam, for those who may remember, the former governor of Virginia, who was most famously seen either wearing a Ku Klux Klan outfit or dressed in blackface from his law school, his med school yearbook. Ralph Northam, a week before that controversy, was on a radio program asked about a baby who survives an abortion attempt and what should be done, and he gave this pretty straightforward answer of sort of saying, well, it wasn't too straightforward. He was kind of hemming and hawing. But he sort of said, well, the doctor and the mother would have a conversation about providing care for the baby, and basically was making it clear that you would just not provide care for a child in that situation because the child is unwanted. And so as a result, just leave the child to die.
Yeah, and John, here, let me just read you, because his language was so shocking. He's talking about late-term abortions and everything, and he says, well, if the mother was in labor, I can tell you exactly what would happen. The infant would be delivered. The infant would be kept comfortable. The infant would be resuscitated if that's what the mother and the family desired.
Right.
And but then this is the most shocking part. Notice the order of operations. You first resuscitate the infant, and then after the infant has been resuscitated, a discussion would ensue between the physicians and the mother.
Yeah. So it's 100% conditioning the provision of medical care not on the healthcare needs of this baby who's now out, who's now an American citizen, who's now alive. Not conditioning,
protected by the
protected by the law, protected by the 14th Amendment, protected by by everything. It's basically conditioning this kid's health care on whether or not mom wants him. And this is where, look, I don't really think there's much moral difference between an abortion and infanticide. They're both bad. But at least I thought we had the common ground that killing babies in America, that everyone, even pro-choicers, are not in favor of killing babies, of killing actual babies who are born outside the womb. And it seems as though that is just, I mean, that's the monstrous part of this, is that it has more or less, again, this is legalizing getting rid of any civil immunity for a mom and a doc who decide not to provide care for, and then giving immunity from criminal prosecution in California for any mom and any doc who decides to do this for just letting a baby die. Maybe a baby is born with some kind of health condition. Maybe a baby, not providing basic care to that baby. We'll deal with more issues relating to this piece of legislation, what maybe our thoughts on its prospects for success, next on Right to Life Radio. AB 2223, introduced in the California legislature to eliminate all civil liability and criminal liability for perinatal death. Perinatal death at the choice of mom or doctor. The bill eliminates civil and criminal liability. It clarifies that there's no civil or criminal liability for any form of miscarriage, for any form of abortion, and for any form of perinatal death, which perinatal death, it means around birth death. And in some jurisdictions, that goes all the way out to 28 days after birth. Now, this can be a complicated issue. And it seems that the California legislature is approaching it with all the subtlety of a jackhammer.
Yep.
Because, okay, what are the ethics of providing someone with healthcare? When does someone need healthcare? The principle that within the pro-life community, and this is sort of from Catholic teaching, but I think it's kind of a reasonable set of principles that a lot of pro-lifers agree with, is that there is a difference between providing extraordinary care versus providing basic essential care. That if something is not unduly burdensome, onerous, invasive, expensive, whatever, to the patient, and will improve the patient's condition, it's a focus on the treatment itself. If a treatment is likely to succeed and not horribly onerous, then that is basic and essential care. And that's something that anyone is owed, okay? If Jonathan were lying on the side of the road and just needed someone to patch him up and put him up in a hotel, and there you go. I would, hopefully someone would be the Good Samaritan and provide that basic kind of care that would be effective. It's within our means to do it. Jonathan deserves that. I don't know why in this situation you're getting beaten up and laid at the side of the road, but
I'm not liking this analogy.
Yeah. So in the case of a child who has survived abortion, now some might argue, well, look, oftentimes in these sort of situations, it's a baby who's survived abortion or a baby with a critical, health condition. You may very well be in a situation where providing medical care is not improving the baby's situation, and it's just prolonging death or something. So if the baby dies in that situation, you shouldn't have the doctors be liable. Okay, that's fine. That's fine. I can understand that. Maybe you have a baby with a terminal diagnosis. Providing medical care is not actually going to benefit the baby. It's just going to be more invasive. It's just going to prolong death. There are all kinds of what's called perinatal hospice, which is a beautiful thing. We have it in Fresno, the Angel Babies program by Heinz Hospice. That a lot of people really appreciate perinatal hospice as a good, as a really wonderful way of dealing with the imminent death of a child.
And John, if I can tell a very personal story, my sister-in-law, my wife's sister, I don't think she'd mind me sharing this story. She and her husband, the first time they got pregnant, they found out about either 20 or 24 weeks that the baby had severe fetal abnormalities. And because the doctor was Dr. George Gonzalez, who was working with them, I know he did not suggest abortion, but I know that in almost any other situation, that would have been the number one thing that they would have pushed was, oh, well, sorry about this, but here, you can have an abortion. In my sister-in-law and brother-in-law's case, they chose to carry that child to term. Little girl lived for about 45 minutes after birth and passed away. And I know for a fact, because it was their experience as well, that experience with I think it was Angel Babies through Heinz Hospice. It was a as you might imagine, a very difficult emotional time, but also something where they did not fear the law. There was no complication in that sense because they were not trying to end the life of this child. They were.
And in that situation, I think things are very clear. Yes. And I think, if you're talking about an up-in-the-air situation, well, that is something that can be dealt with through the normal processes of law.
This law is not addressing couples like them or families like them.
To basically say that, well, we're eliminating all civil and criminal liability. Well, no, there might be a situation where a doctor's just sort of, well, the mom doesn't really want it. I don't really want it. We don't want to deal with the expense of taking care of this baby. You've opened yourself up to that being the scenario. And as a result, you've basically legalized letting babies die. I mean, it's a horrific thing. A baby that maybe could benefit from easily providable healthcare treatment just being let to die with no civil or criminal liability for anybody involved. It's really going way out there. California legislature also approved a bill for getting rid of copays and deductibles for abortion. We'll explain whom that's really benefiting. It's not patients who are chiefly concerned with here. It's the abortion industry. Next on Right to Life Radio. Now, we were going to talk about this bill, Jonathan, about basically this bill that the California legislature passed that eliminates all out-of-pocket expenses for abortions for anyone who has insurance. Instead, though, and maybe we'll get to that at some point in this segment.
It's a long
We'll figure it out. It's a long show. Whatever. We'll figure it out. There's this other provision in AB 2223, which we've been talking about for the first half of the show, that you pointed out that I think is really insightful.
It really is just, John, it's kind of the kitchen sink. They've got so much stuff in here. I mean, I've seen our friend, my colleague, work colleague, Greg Burt, referred to this bill as the, Gosnell Indemnification Act.
Yeah.
That's,
that's a good way of thinking about it.
But this goes beyond even just the doctors, and it essentially, I mean, John, I'm no attorney, but reading this section that we looked at in the break,
it seems to very explicitly legalize 9-month abortions if done sort of at home. So
Yes.
so let's give the fuller let's give the fuller context for this, because we have to kind of understand how California law functions with regard to late-term abortions. All right. In California, the legal structure is abortion is legal before fetal viability and is illegal after. Now, it's illegal after fetal viability with a big exception. All right? The exception is for any pregnancy that implicates maternal health. And that term, maternal health, is so broad that you can drive a semi-truck through it. Basically, health can mean familial health. Like, my family dynamic will be upset by this. Essentially, any unwanted pregnancy implicates health sufficiently to justify a late-term abortion. And the determination, though, for whether the woman's health is implicated is made by the doctor. Okay?
You at least, theoretically, you have to get a rubber stamp. Mm-hmm. It can be completely specious and completely made up, but you still are supposed to get a doctor to sign off on it.
Yeah, and there are lots of abortion doctors who would say any pregnancy involves significant health risks, and so I would always be willing to justify a late-term abortion for any, pregnant person, because God forbid we say women, for any pregnant person who asked. One of the provisions of AB 2223, which again, it eliminates all civil and criminal liability for any form of perinatal death in addition to abortion or miscarriage. It furthermore eliminates criminal liability for certain kinds of late-term abortions. Pretty much just it eliminates civil or criminal liability for an individual woman engaging in an at-home abortion, more or less, sort of a home-done, the kinds of abortions that the abortion industry supposedly doesn't want, the dangerous at-home abortions with a coat hanger, whatever, that whole thing that is the specter that they put forward, that if you favor any kind of legal restriction on abortion, you want women to die from self-inflicted abortions with coat hangers. Basically, the California legislature is trying to legalize those exact kind of abortions in late-term situations. So remember, late-term abortion in California is only legal if a medical provider determines that the late-term abortion is necessary for preserving maternal health. This is basically this provision of AB 2223, and Jonathan, maybe you can pull it up and get the exact language here.
Let me read you this section. This is from the code. It's under Section 8. It says, Section, literally, 123468 of the Health and Safety Code is amended to read, and then it says, the current language says, the performance of an abortion is unauthorized, illegal, unauthorized, if either of the following is true. The person performing it is not a healthcare provider, or the abortion is performed on a viable fetus, and in the good faith judgment of a physician, the fetus was viable, or the continuation of the pregnancy posed no risk to the life or health of the pregnant woman. So,
which they amended that one to say from pregnant woman to say pregnant person.
I know,
because God forbid we acknowledge that women are the ones who have babies.
But literally, John, it is this already is an incredibly low bar, because essentially all you need for an abortion to be legal in California under current law is, well, it has to be a healthcare provider, which now under some of the new laws they're working to pass, as long as you're a nurse practitioner. You know, if you've spent a couple evenings at medical school, I'm kidding. It's a little more strict, but really, if you're a nurse practitioner, if you're a nurse midwife, or certainly if you're an OBGYN, if you are an abortion provider, the abortion is basically legal. And you would essentially have to get that doctor to agree, to testify that, well, I thought the fetus was viable, and I thought that continuing the pregnancy posed no risk to life or health.
Yeah,
In
which
this
is not
case-
going to happen.
In this case, they've added one single line here, and it says, an abortion is unauthorized if performed by someone other than the pregnant person, and if either of the following are true.
Right. So
just by putting in this one line.
Yeah. So this is basically given carte blanche. I mean, it's separating out any abortion. So abortions are only unauthorized if someone other than the pregnant person is doing it who fails to comply with any of these provisions.
But
meaning they've sort
if
of
you're a
separated
pregnant
out.
woman-
Yeah. So they've separated out any pregnant woman doing an abortion on herself, presumably. That is now going apparently to be legal according to this standard, according to this bill.
Which the idea being, I mean, John, I hate to be so gruesome about this, but if you talk about, you know, back alley abortions or
Right.
coat hanger abortions or whatever it is.
That has been the fundamental premise of the pro-choice movement for 50 years, is to get abortion out of the shadows, to get rid of, have abortion be safe, legal, and it used to be rare. Now they want it to be safe, legal, and accessible. But now they are decriminalizing unsafe abortions.
Yes.
I mean, they're going to take away any kind. Look, I guess in a certain sense they'll argue, well, we shouldn't criminalize people for, but isn't that the whole emphasis of what you're trying to do in all this? That you're going to, the whole emphasis and point of all of this work that pro-choicers have been doing is to stop people from having abortions unsafely in back
unsanitary.
alleys, doing homemade methods. And again, this is now going to legalize abortion through all 9. So again, let me just repeat this. California law says that abortion after the fetus is viable is illegal unless the doctor says, unless some healthcare provider, authorized healthcare provider, says that it is necessary for preserving the mother's health. In an at-home abortion situation, you could be killing a post-viable baby with no determination from a healthcare provider that maternal health is really threatened. Now, I get that the pro-choice side really views the health exception as just a rubber stamp, but this is an illegal abortion. So the only kind of, but this is an abortion that does not impact maternal health. That no one has determined that this abortion impacts maternal health. No healthcare professional has determined that this abortion, this at-home abortion, impacts maternal health. So shouldn't it be viewed as an illegal abortion? Or do we just purely view the health exception as the rubber stamp we have 9-month legal abortion in California? Liberals constantly push back on that and say, well, abortion's only legal through viability in California, ignoring the health exception aspect. So I'm sort of stunned that the legislature would go to the extent of saying, we're going to eliminate any kind of criminal and civil liability for any at-home abortions whatsoever, even if it's on a viable, healthy pregnancy, in a viable baby, in a healthy pregnancy, 7 months along, nothing. There's no legal liability whatsoever.
And John, let's say that this passes and you have a brave DA like Kings County DA, whose name escapes me right now, but he was the one who brought this initial case against the woman whose child died. I mean, let's say you have any DA in a conservative part of California,
right,
who says, no, this is horrible, and I'm going to actually bring charges against this woman because there is not evidence that her baby died, but there's evidence that she affirmatively smothered her child after birth.
Yeah.
The final section of the bill. A party aggrieved by conduct or regulation in violation of this article may bring a civil action against an offending state actor in a federal district court or a state superior court.
Mm-hmm.
A state claim brought in federal district court shall be a supplemental claim to a federal claim. And then, upon a motion, a court shall award reasonable attorney's fees and costs, including expert witness fees to Planned Parenthood workers, of course.
Right, of course.
And other litigation expenses to a plaintiff who is a prevailing party in an action brought pursuant to this section.
Yeah, so basically, I'm guessing this is to basically allow some kind of lawsuit for wrongful prosecution against any district attorney who tries to prosecute this.
I mean, if you are, let's take the Gosnell example. If you are a woman who, God forbid, smothered your newborn, or you are a doctor who helped a woman basically
kill a born alive baby.
Yeah,
or neglect a born alive baby.
You are immune. You are exempt from any kind of prosecution. And if a DA, an enterprising DA or defense
Police
attorney
or
says, "Look, I can't let this stand. This is murder."
Yeah.
You've killed a child.
You've now you've basically completely disincentivized any district attorney from looking into abortion clinics that might be Kermit Gosnell-esque situations where Gosnell was having babies born alive and just killing them.
And not just disincentivized, you're threatening them. You're basically you're blackmailing them. You better look the other way. You know, nice law practice you got over there. It'd be a shame if something were to happen to it.
Right. So and it's really, I mean, this is going against state officials. This is going against district attorneys or people like that. So it's this is really, really bad legislation. I mean, in this design, I mean, you know, in case you haven't caught on this, in their desire to address one legitimately difficult case in Kings County, where a woman was being prosecuted because she was abusing drugs and that was resulting in miscarriages, and an overzealous DA, again, I don't know all the details of the whole thing, but an allegedly overzealous DA prosecutes this woman for this fetal demise. And you're going to basically pass this legislation to flat out legalize infanticide. I mean, it's astonishing. Legalize abandoning children and provide civil liability for a district attorney so that he or she can never actually investigate it if there is an abortion clinic that's killing born alive humans.
Hard to know what to say, John.
It's really, really bad. And I'm hoping that even this is too crazy for California, but I guess we'll wait and see. All right. When we return, we'll discuss paying for abortion through insurance plans, getting rid of copays and deductibles, next on Right to Life Radio. Right to Life Radio. Thank you all so much for listening. All right, Jonathan. The state legislature passed a bill that we've been talking about for about 2 years here, SB 245. And this bill specifically eliminates all out-of-pocket expenses, copays, and deductibles for abortions for anyone who has insurance. Now, as you know, there is such a thing as a free lunch, and so when you just wave a wand and eliminate the copays and deductibles, that means those expenses just disappear into the ether, right? That's how economics works. That's how pricing works. No. So obviously, the costs for this are just going to be transferred to people's insurance premiums. But Jonathan, I think you've pointed out this in connection with another piece of legislation the legislature passed last year to basically prevent insurance providers from telling the insurance policyholder about when individuals on the insurance policy use the insurance plan for certain kinds of sensitive services. So basically, the legislature passed this bill preventing insurance companies from in any way informing the holder of an insurance policy that, for example, his daughter had an abortion,
right,
or that the wife had an abortion, or if it's the mom who holds the insurance policy, that her daughter had an abortion. Planned Parenthood and other pro-choice advocates pitched this as being about protecting the privacy of the girl or the wife or whoever on the insurance plan who's getting an abortion. You pointed out that really this might be more about lining the pockets of Planned Parenthood with a nice, fat, private insurance-funded abortion.
Yep.
So,
well, you think about this, John, like anything else. My I might have mentioned this story on the podcast before, but my friend Greg, our good compatriot up in Sacramento, he's the director of capital engagement for California Family Council. As an example, his daughter broke her foot. It's either her daughter or his daughter or his son broke his foot.
Yeah.
And went to the doctor, and they gave him an orthopedic walking boot.
Right.
So this is literally something that is not super fancy. It's not custom made. It's just basically a bunch of Velcro.
Yeah.
And
I've
some
had one of these,
metal stays. And I had one too when I broke one of my bones in my foot. And then he gets a bill from his insurance company or from the hospital. Technically, with the health sharing plan, it's free. So, or I'm sorry, it's not free. It's cash
covered.
pay.
Yeah,
cash pay
cash
system.
pay. Yeah.
So he has to go and he gets this bill for this boot, which is $1,500.
Right.
And he kind of freaks out a little bit, and he goes online. He goes, "What's the deal?" And he goes, "Oh, I'm sorry, because you're a cash pay patient. We don't negotiate. We don't."
Yeah.
So he goes on Amazon, and he finds out that this exact same boot, he looks up the model number and everything on Amazon, is $89.
Yeah. Exactly. Yeah.
So the idea is that this is a basically a 1,500% markup,
Right.
and that is how hospitals and insurance companies work. Now, if you have to pay for it out of pocket, you're going to go, no, I'm not doing this, and I'm going to take care of this.
Yeah.
But now, when it comes to abortion, if Planned Parenthood is able to hide this from the parents, they can now charge whatever the heck they want.
Right.
And the parents will never find out what the procedure is. They don't understand why these high amounts are going in. And after SB 245, essentially now there's no competition because not even the parents can dispute what the copay is.
Right. And I mean, even, I think before in under the current regime, in a pre-SB 245 world, if a kid wants to have an abortion, doesn't want the parents to figure out about it through the insurance or something, they could get like a Medi-Cal funded abortion. They could get some kind of emergency Medi-Cal coverage. And guess what, folks? Medi-Cal reimburses way worse than private insurance plans do. So the idea that Planned Parenthood was interested in, one, eliminating copays and deductibles, and two, keeping private from parents when their daughter has an abortion on their insurance, to think that that was about protecting kids' privacy, no. The point of it, there were ways of protecting kids' privacy without this. The real motive here is to get privately funded abortions. That's private insurance funded abortions to line the pockets of Planned Parenthood because that reimburses way better. Anyway, that will do it as Dean Martin plays us out with Return to Me. This was the song Holly and I danced to at our wedding, our first dance. So there you go. Thank you so much for listening to Right to Life Radio. We'll see you next time.